I'm Leigh, one of the founders of Aspire Advocacy, and I wanted to discuss the IEP tips around due process today. You're probably thinking, due process? Advocate? What are you talking about? As an advocate, I don't do due processes. I send you to an attorney for that. What I can do to be helpful, though, is to help you get your paperwork ready to go, to help you through IEP meetings that establish that you've asked the school in a reasonable manner for what your child needs, and help you get organized so that by the time you go to the attorney, they can take a look at your paperwork and take you to the next stage in that journey. Due process is when you and your child's school district cannot agree on typically services or placement in an IEP. You could technically have a due process over goals, but that's rare. Usually you can come to some sort of compromise on goals. Due process is this big term. I remember being terrified of due processes, rightly so. You hear of cases where families spend six figures on them, and if they lose the due process, they have to pay those bills. It's terrifying. I could only come to terms with going to due process by knowing I would never pay off the debt, but that it was worth it for my child. However, there are some steps short of going before a judge and spending tens or hundreds of thousands of dollars. So the way the process works is either you or the school district file for due process. One of you contacts your attorney writes up the complaint, sends it to the other side's attorney, and there you go. Between the time when you file for due process and when it's resolved, a couple things can happen. You can settle in an informal meeting prior to taking it to the next step. You can often get together with the other side and see if there's room to maneuver it, knowing that that due process date is waiting. The next step you can do is take it to formal mediation. And what happens is you, your attorney, the district and their attorney, and a judge who's working as a mediator, not technically a judge, but they are a trained judge, all meet in one room, and then often what happens is you'll all start in one room, and then the judge will move one team to a different room, and you'll either stay in that room or you'll go to the other spot, and then the judge will go back and forth to see if he or she can bring you to a compromise. Most cases are settled in mediation. It's often a confidential agreement that you sign that you say you won't reveal the terms or won't tell everybody else about it so that other parents can't benefit from it. And then your child will get the services and placement stipulated in that confidential agreement. If you're not able to agree at mediation, you would then go to due process. The odds for parents are not great in due process. I believe last year about 13-14% of cases were decided in favor of parents. So that's the bad news, and a really good year in the last 10 years was about 17 or 18%. So the system is really not stacked in favor of parents, but often we can get most of what we need in the mediation because the district in most cases doesn't want to go to due process a whole lot more than we do. So I hope that helps kind of understand the process a little bit, because most parents tend to think it's all or nothing. If they file due process, it's straight to court, but that's not typically the case. So again, please contact me if you'd like more information. Thanks for watching.